สวัสดีครับท่านผู้ชมเพื่อนผู้ฟังทุกท่านนะครับยินดีต้อนรับเข้าสู่ KRAC INSIGHT ในตอนล่าสุดนี้นะครับและตอนนี้เราได้รับเกียรติอย่างยิ่งนะครับจากผู้เชี่ยวชาญที่ศึกษาเรื่องการต่อต้านคอร์รัปชันนะครับและเรื่องการคอร์รัปชันเองนี่แหละนะทั้งในทั่วโลกนะครับโดยเฉพาะในสหรัฐอเมริกานะครับเราอยู่กับ Professor Matthew Stephenson ครับ Hi Professor Matthew Stephenson. Welcome to KRAC INSIGHT.
Thank you very much. Thanks for having me.
Thank you. Today, Matthew is with us at Chulalongkorn University as he's visiting and giving lectures to students here at Chula. So welcome again to Thailand. Welcome to Chula. And thank you very much for your time today.
Thank you very much for having me. I'm glad to be here.
Thank you. So before we start talking about the issue that we've prepared, may I introduce you very briefly. So Matthew Stephenson is a professor of law at Harvard Law School, where he teaches administrative law, legislation and regulations, anti-corruption law, and political economy of public law. His research focuses on the application of positive political theory of public law, particularly in the area of administrative procedures, anti-corruption, judicial institution, and separation of powers. So, and this links to the topic that we would like to discuss today,
Yes.
which is FCPA, Foreign Corrupt Practice Act, and FEPA, the Foreign Extortion Prevention Act as well. From what I've heard, it's been in the past few years, FCPA has been used a lot in various countries. In Thailand, there has been several cases as well where the FCPA has been enforced and many companies has been fined largely. So before we get into all these cases and what we should learn and prepare ourselves, can you explain to us very briefly what is FCPA and perhaps FEPA?
Sure, I'd be happy to. I know some members of your audience might already be very familiar with the FCPA, but maybe not everybody. So the Foreign Corrupt Practices Act is an American statute. It was enacted in 1977 following a number of very high-profile scandals where American companies had been caught paying bribes to officials in foreign governments. And there were also some companies that as part of a kind of quasi-amnesty program had voluntarily disclosed under the promise of immunity to the United States Securities and Exchange Commission that they had maintained separate accounts that were used for various purposes, including foreign bribery. And this created a great deal of concern for a variety of reasons. If you want, at some point we can go into the history and background, but for now I'll just state that in the wake of these scandals and these disclosures, the United States Congress enacted this statute, the Foreign Corrupt Practices Act. It has been amended a couple of times since then, and so I'll focus on the statute in its current form. This FCPA has two main provisions, the so-called anti-bribery provisions and the accounting provisions. So the anti-bribery provisions are the ones that most people usually think of. They prohibit those entities that are subject to FCPA jurisdiction from corruptly offering or promising anything of value to a foreign public official for purposes of obtaining or retaining business. So who are those covered entities? What entities are covered by the FCPA? So first, the FCPA's anti-bribery provisions apply to so-called domestic concerns. That would be American citizens or American companies. When an American citizen or an American company is engaged in business dealings abroad and pays or offers or promises anything of value to a foreign official to help advance their business interests, that would be a violation. Second, the Foreign Corrupt Practices Act's anti-bribery provisions apply to issuers of securities on U.S. exchanges. So if you issue securities, if you issue stock, for example, on the New York Stock Exchange or NASDAQ, or if you issue other securities in the United States, then you're covered by the FCPA. That's important because many non-American companies issue securities in the United States and list on United States exchanges. So many major multinational companies in Europe, for example, Japan, elsewhere, will list their securities in the United States. And that's significant because that means they are potentially subject to liability under the FCPA's anti-bribery provisions. Finally, the FCPA applies to any other entity, even if it doesn't issue securities in the US and even if it's not a domestic concern, if any part of the unlawful bribery transaction takes place within the territorial jurisdiction of the United States. So basically, if you are a US firm or person, if you list securities in the United States, or if you take part in any bribery scheme that takes place within the United States, then you're covered by the anti-bribery provisions. They're both civil and potentially criminal penalties for violating these provisions. Then there's a set of provisions called the accounting provisions that only apply to issuers of securities in the United States. These accounting provisions require the issuers of US securities to maintain adequate books and records that accurately keep track of expenses and payments and so forth, and that also maintain an adequate system of internal controls to assure that company funds are only spent in ways that are consistent with official company policy. So these particular provisions are actually not specific to foreign bribery. You can violate these accounting provisions in other ways as well. They were part of the FCPA because, as these scandals in the 1970s revealed, very often bribery took place because companies were maintaining so-called slush funds or separate accounts to facilitate this bribery behavior, or were simply looking the other way and not really paying attention to how their foreign employees or associates or affiliates were spending company money. And so the accounting provisions say if you've listed securities in the United States, you have to maintain accurate books and records, and you have to maintain appropriate controls to make sure that money is being spent in a proper way. So the FCPA is enforced jointly by the United States Securities and Exchange Commission, which enforces the civil provisions of the Act against issuers of securities, since the SEC has general responsibility for regulating securities in the United States. The Department of Justice enforces the civil provisions of the FCPA against non-issuers, and also has general responsibility for criminal enforcement of the FCPA. So that's a basic overview. There are a lot of interesting questions about different aspects of the FCPA and what it means and how it's enforced. I'll let you take the lead with respect to what you want to ask about, but that's a general overview of what the statute does.
Thank you very much. That's very interesting. And may I ask, so basically it's something that helps reduce bribery, corruption in private sectors, and not only not only domestically in the United States, but outside the United States as well. So why would the United States be interested in enforcing anti-bribery law outside the United States?
It's a great question. Many people have puzzled over this because some people, frankly, including the current United States president, say, why should we, the United States, put ourselves at a disadvantage? Why should we care, basically, if our firms pay bribes in foreign countries? If an American firm bribes a Thai public official to win a contract in Thailand, that would clearly be a violation of Thai law. The Thai authorities could investigate and prosecute the American company or company employees who were involved in the bribery, so why should the United States get involved? There's both a historical version of this question, why as a historical matter did the United States Congress in 1977 actually enact the statute? And there's a more contemporary version of the statute. What interest does this statute serve for the United States, regardless of whether those were the original reasons for the FCPA. So let me try to touch on both of those. They overlap, obviously. They're not necessarily the same. So in the 1970s, at least part of the motivation for the FCPA, I think it's fair to say, was political, right? So the Cold War is still going on. There's a propaganda struggle between the United States and the Western Bloc and the socialist or communist or Soviet bloc. And it was a great embarrassment to the United States when information is disclosed that flagship U.S. companies are paying bribes to public officials in key U.S. allies like Japan and Italy, for example. And so part of this is a sense that for the United States' reputational purposes, it needs to crack down on this. And more generally, anti-American, anti-capitalist propaganda would emphasize that the system is all rigged, it's not really about fair competition, it's all, the evil corporations controlling everything. And so there was a kind of foreign policy interest in this. It's also worth noting that the moment when the FCPA gets enacted is a moment where both domestically and internationally, the U.S. government is putting a lot more emphasis on morality and in the context of its conduct at home and abroad. So this follows the so-called Watergate scandal that forced President Richard Nixon to resign. A lot of the information actually about the secret slush funds companies were maintaining to pay bribes emerged because of that scandal, because there were a lot of secret slush funds that were used to make illegal campaign donations, and it turns out those same slush funds or very similar ones were being used to pay bribes abroad. The Carter administration placed a lot more emphasis on things like human rights in its foreign policy. Domestically, there the enactment of the Ethics in Government Act, the War Powers Act, and so forth. So it also fits within the ethos of the time of the late 70s that there would be more emphasis placed on this sort of thing. I would say there's also a sense that although people often will talk about how the FCPA disadvantages American firms relative to foreign firms, it's not really true, especially, this was true even back in the 70s, but especially true now. So oftentimes what would happen is one American firm that paid bribes would beat out another American firm that didn't pay bribes. So especially in a period where a lot of the overseas activity is driven by American companies are competing with each other. Some of those American companies don't particularly like the idea that their competitors are getting away with things by paying bribes. I would say, let me add to the mix a few more considerations. Maybe these are less part of the historical motivation, but have emerged. I will say that prior to the current administration, which we might talk about in a moment, there was a sense that the U.S. has a strong foreign policy interest in promoting good governance abroad, in promoting stable, friendly governments abroad, and the FCPA helped with that. Both directly because corruption can undermine governments and sow distrust and lead to destabilization, and indirectly, this relates to what I said before, through reputational impacts. There are also just people, and including people in the U.S. government, who genuinely care about development, about promoting international development, about addressing global poverty, about addressing issues of global public health and so forth. And there's a general widespread view that corruption, including corruption driven by transnational corruption, undermines these values. I will also say, returning to the interest of the American business community, so one thing I did neglect to mention before, but it's worth emphasizing, especially now, non-American companies, many of them are subject to the FCPA. Not all of them, but again, this is what I said before. So if you list on a U.S. exchange, then you are subject to the FCPA. So I think of the 10 largest FCPA cases in terms of total penalties imposed usually through settlement, I haven't checked the statistics recently, but I think it's something like 7 or 8 of them are non-American companies.
Oh, okay.
Yeah, absolutely. So if you don't list on a U.S. exchange and none of your bribery takes place in the United States, you're not covered by the FCPA. But if you are a company that operates in the United States, if you're Siemens, for example, the German company, that's one of the big cases, then absolutely, if you're Alcatel or some other foreign multinational, you can be subject to FCPA jurisdiction. Now, the other thing I want to say about the business community is many people in the business community, it's true, have complained about the FCPA and complained about the costs and burdens it imposes. But some people in the American business community will say, sometimes a little bit off the record, that they like the FCPA because they don't actually want to pay bribes, and the FCPA provides a convenient face-saving excuse or justification. So imagine I'm an American businessman and I'm here in Thailand, and imagine you're a Thai public official and I really want to open this factory and I need to get a permit from you, and in the course of the conversation you're like, well, I'd like to give you this permit. Maybe you could make a donation, right, to this numbered bank account, or maybe you could help me out. And it's a little bit awkward to say, no, I do not do that. How dare you ask me if this? Like we have a relationship. It can be considered insulting. It's sometimes easier if I can say, I know what you're saying, and I would love to help you, but these crazy zealots back in Washington, D.C.
Blame them.
Blame them. I could go to jail. My company could find billions of dollars.
Right.
It's just not worth it. So it becomes a way for the companies to say, look, we have an official company policy against this. I'm sorry, the U.S. government has tied our hands. So how often this happens, I don't know, because no one wants to talk about this out loud. But I've heard from many people who've had either direct or indirect contact with American firms who do business overseas that have said they don't necessarily mind the FCPA. They don't want to. A lot of them don't want to pay bribes. A lot of them have discovered that if you say yes once, you can never stop.
You have to continue
paying. Never stop.
Yeah.
You're going to keep on paying because now they know you're a bribe-paying firm, and once you're in for a little bit, and so they actually don't mind it so much. So that's a cluster of reasons, I would say, why historically, both historically and in terms of more recent years, the U.S. has had an interest in enforcing the Foreign Corrupt Practices Act. It's important to note that although the FCPA was enacted in 1977, vigorous enforcement of the FCPA didn't really start until the late 90s, early 2000s. So there was no enforcement, but there was a period of several decades where you get maybe one or two cases a year, and they weren't that big. And most major law firms would maybe have one or two lawyers who worked on FCPA matters as part of a broader portfolio of white-collar criminal work or corporate compliance work. Now, many major law firms have entire FCPA units, or lawyers who are devoted to just that issue, because it started in the late 1990s, but really in the early 2000s and forward, up until very recently, there was just an explosion of vigorous FCPA enforcement. So it's not like the statute was vigorously enforced right from the beginning. There was a significant change.
Yeah, and a few years ago, I had an opportunity to assist one of my mentor, อาจารย์สิริลักษณะ who worked on a case that is related to FCPA, and she mentioned that FCPA is great, but somehow when the US government fines the company, the fine actually goes to the US government instead of country where the bribery occurs, like Thailand. Has this issue like this been discussed?
It has been discussed, not in the US. No one in the US government takes this terribly seriously, I don't think. I shouldn't say nobody. Some people have complained about this. It strikes me that, first of all, this is normal, right? When the United States imposes fines on companies for violating laws, typically those fines go to the United States Treasury. Because, of course, a country like Thailand can bring its own action against, I mean, again, I gave the example, if I were an American company or representative of an American company and I paid a bribe in Thailand, my company could be on the hook, and the Thai authorities could bring an enforcement action, and they could recover substantial fines and penalties that would go to the Thai government, which, by the way, isn't necessarily the victim of corruption either. That's another issue we should get to. But the thinking here is a violation of the FCPA is a violation of the sovereign interests of the United States, and when the U.S. enforces its law, it recovers penalties. They go to the same place penalties for pretty much anything else go, which is to the general U.S. Treasury. And that's as it should be, because the point here is essentially deterrence. Right? If you take the idea of victim compensation seriously, and some people do, then you would need to think a little bit more carefully and systematically about who exactly the victim is and how one determines appropriate compensation for the victims. So, again, taking my example, if I want to open a factory in Thailand, if I want to open, I don't know, a soda factory, and I need various licenses and permits to open my factory, and I pay bribes in order to get them, who's the victim, right? So I'm not saying corruption is a victimless crime. That's like the opposite of what I'm saying. But the victims are diffuse, right? It's society generally through all sorts of indirect channels. It's hard to say that the Thai government was the victim there. The people of Thailand generally.
Thai people.
But how do you calculate the damages? I mean, typically in law, if you want to get compensatory damages in the ordinary sense, you need to show some kind of direct causal link, and the damages need to be reasonably quantifiable in some way, and that's not typically the way. The other thing I would say on this is right now this is a little bit irrelevant because the Trump administration has suspended all FCPA enforcement.
That's what's going to be my next question.
I absolutely know that's going to be, many people are going to be thinking about that, but put that aside, focus on previous administrations that did enforce the FCPA. It's not clear to me that if there a general principle that the money recovered in FCPA actions needs to go to the foreign country, that the US would have nearly as strong an incentive to enforce the statute. Because people complain about it, will say, why are we spending all this money? We have problems here at home. Why are we spending money going after companies that paid bribes in Thailand? Let Thailand deal with it. Part of the answer to that is we recover more in penalties than we pay to enforce the statute, or at least they're comparable. So this is not like a losing proposition for the United States government. I don't think it's accurate to say that it's a money-making proposition for the United States government. The amounts of money still are quite small relative to the overall United States government budget. But it's at least a way to say this isn't just altruism. This serves U.S. interests, and it's actually not a money loser. If, politically, even before the Trump administration, politically, if it were generally understood that recoveries in FCPA cases went abroad, I think that would not be great. Now, I will say, one last thing I'll say on this, there are a few particular cases where the U.S. government, often in partnership with foreign governments or foreign entities, has experimented with finding ways to use the recoveries in FCPA settlements to promote various kinds of social welfare in the countries where the corruption took place. So there was a well-known case involving, I think it was Kazakhstan, where there was a creation of a charitable foundation and used a portion of the settlement. In part of the arrangement with the Brazilian authorities settling a case involving a Brazilian state-owned oil company, there was now this wasn't the U.S. government doing it directly, but there was an understanding that the portion of the settlement that the Brazilian authorities recovered would be channeled through a charitable foundation. Now, a lot of things fell apart. I don't want to go into the details, but a lot of things went wrong. So there was that idea, and there's some settlements, similar settlements in other countries. For example, the UK's Serious Fraud Office reached a settlement with a company. I'm trying to remember which one it was, but part of the settlement involved that company spending a portion of money to purchase, I think it was ambulances in Tanzania. So this happens sometimes. So I don't want to make it seem like this is completely outside the discussion, but it's not the norm. I mean, the norm for the FCPA is the norm for any number of other statutes. If a company commits securities violations generally, then of course there can be civil securities fraud action brought by private plaintiffs, but the criminal actions, the criminal fines, those go to the U.S. Treasury. That's just sort of normal. Okay, so in addition to just they should care because it's good and it's important for the world, or why should they care specifically professionally? Well, it depends a bit on the kinds of interactions they have with non-American firms doing business in Thailand. So again, it's not just American firms. It could be a multinational that lists on U.S. exchange. So when American firms, enter into agreements with non-American firms in other countries, because they're worried about FCPA liability, they will include in the contract, in the representations and warranties section of the contract, a lot of requirements on those firms not to engage in unlawful activities, including bribery. So that's one thing you need to be aware of. Your American partners and other non-American firms that are covered by the FCPA or other similar anti-bribery laws may be very concerned when they establish a relationship with you. Part of that is because, depending on the nature of the relationship, if the Thai partner engages in various kinds of unlawful conduct, the American partner could end up in trouble. So certainly, if an American firm has a Thai subsidiary, there could very much be a concern about unlawful bribery. There could be concern about acting as a co-conspirator or facilitator of a bribery scheme. There are a variety of ways that the Thai entity might find itself in, or might either find itself in legal trouble or get its American partner in legal trouble. There are situations now where some Thai firms, at least, are going abroad. And I believe at least some Thai firms might issue securities on U.S. markets. So when that happens, again, the Thai firm could find itself subject to FCPA jurisdiction. So if you're going to go list on securities in the U.S. market, this is not just the FCPA, There are some advantages to that, traditionally in terms of your ability to raise capital, but there are obligations and associated risks that come with issuing securities. FCPA, potential FCPA liability is among those risks. Again, if you are in the United States, within the territory of the United States, even if you haven't listed on a U.S. exchange, if you go have a business meeting in New York and start talking about paying bribes to some foreign government official, now maybe the U.S. government wouldn't bother prosecuting you for that, but that could at least land you in some degree of trouble. So there are a variety of ways that a Thai private sector person could find themselves affected by the Foreign Corrupt Practices Act for sure. And obviously, if you are, I shouldn't say obviously, because I'm not sure what's obvious and what's not, but if you're a Thai person who is employed by an American firm doing business in Thailand, then very much you could end up being subject to FCPA liability.
Now you can say obviously because, but do I understand correctly? If I own a Thai business, let's say I sell soda again, I never have any exports to the U.S. markets. I never list in U.S. stock exchange, not anything. One day you, who works on, who owns another soda factory in the U.S. comes and we have transactions. And you then become my partners. But then I've never traveled to the U.S. in my life. But then I paid bribes to a Thai authority. You could be liable to.
It depends on the nature of the relationship. So, and really, because all these cases settle, they never go to trial. A lot of this can depend on what the Department of Justice and the SEC think about the nature of the relationship. So, if you are effectively acting as my agent, then I could definitely, as the American, be in trouble. Right? So you're not allowed to pay bribes even through a third party. So the easier one here, forget about the soda thing. Suppose you're a consultant. Suppose you set up shop and you say, I help foreign businesses interface with the Thai government. And if you give me a bunch of money, I can solve your problems. So there's nothing inherently wrong with people offering these kinds of services, right? Many investors who are dealing with a foreign country where they don't speak the language, they're not familiar with the culture, they can hire local agents to assist them. So there's nothing inherently illegal about this, but very often these so-called local agents are really just funnels for paying bribes. So the service you actually offer is, I pay you a very large sum of money, you keep a small percentage of it and pass on the rest of it to a foreign official to facilitate my transaction. So that if that's the business that you're in, that's going to be a clear FCPA violation if the American partner knew, and knowing here in the law doesn't necessarily mean literal actual knowledge. It can mean, you're not allowed to have what's called a head in the sand approach. If a reasonable person would have known or would have seen the red flags, then you could potentially be in trouble. So you could generalize this to other kinds of partners, right? Like if I want to get involved in the Thai market, I want to sell soda, I'm not familiar, you have like a small soda bottling plant and you say I can be your local partner. Again, there's nothing wrong with this, this might be fine. And it may be, if it really is kind of an arm's length agreement, the American partner might not be affected at all by your unlawful conduct. But if really the reason I'm partnering with you is because I kind of know that you're going to be facilitating my entry into the market by funneling bribes to government officials, then the American firm can be in trouble.
Now this is a big issue because I've talked to many of people I met at seminars and workshops that talks about corruption and also sometimes about FCPA. And many of them mention that, I don't do any transaction with the US companies, but I have friends, I have partners in the US, so I'm not liable to any of these laws. So that's not true.
Well, it could be. So again, it's going to be pretty fact specific. So again, if we just have business dealings, again, pretend I'm an American company and you're a local Thai business person, and we just have business dealings with each other, and it turns out you're paying bribes, that's not necessarily going to make me liable and certainly not going to make you liable, right? So if I need to purchase certain things from Thailand and you're one of the sellers, or if I'm looking for an appropriate retailer for my products and you were the one who, and it turns out later that you got a lot of market share because you were paying a lot of bribes, I'm not necessarily going to be on the hook directly for that. So I don't want to give your listeners a distorted impression that any time you like have any contact with any kind of American business person, they or you are now going to be on the hook for the FCPA. But it is at least possible if the nature of the relationship is one where actually what's going on is that you've got an entity covered by the U.S. Under FCPA jurisdiction, which again is not just a domestic concern but could also be an issuer that is offering things of value to foreign officials for purposes of obtaining business, then FCPA liability could attach. And the mere fact that the American firm maintains what they like to think is like plausible deniability doesn't automatically insulate.
Right. So that's the kind of like the direct effect. Now there's been saying of an indirect effects. For example, I've been in this seminar and they asked one of the big purchasing platforms to come and give presentations, and they said that many U.S. companies are now afraid of the FCPA because, as you mentioned, it's been the rate of enforcement has been increasing in the past years before this administration. So they're applying this corruption perception index, the index that you talked about last time we talked in this in the session, into as a criteria for U.S. companies to decide whether to buy products from this companies in this country. So basically, indirectly, all Thai companies would be affected, right? Because we have low CPI score, which means we are high risk country. So they better buy something else from more expensive products. The same thing from other countries with high CPI score. What's your opinion on that?
So I don't know the details of the particular issue you're talking about. I'd be a little bit surprised if companies were really worried about just ordinary arm's length transaction purchases from a country that was known to have a significant corruption problem. So my understanding is that you don't violate the FCPA merely by purchasing a product from a firm that might have violated the FCPA. You certainly could get in trouble if you're trying to sell your product in such a jurisdiction and the sale of your product requires interacting with government officials. So the version of the story that I've heard more often, now there's a second aspect, which is the CPI, the Corruption Perceptions Index as a measure. I'm going to get to that in a moment. But there are two issues here. One is in what ways might the perception of widespread corruption affect an American company or some other multinational company's willingness to do business in the country. And then there's the issue of those companies using these indexes like the CPI specifically as a measure of the corruption. So let me talk about the first thing first and the second thing second. So the first thing, if you're selling in a particular country, then it's pretty obvious why you could be worried about the FCPA, because in many countries, especially many heavily regulated countries, it's very difficult to operate there, it's very difficult to sell products there without interacting with the bureaucracy, and if the bureaucracy is known to have a very significant corruption problem, then this is a high risk, it could raise your costs, even if it's not obvious at the beginning, right? So I want to sell fruit in Thailand, which is silly because like if you have so much great fruit, why would you buy American fruit? You want to sell something else. And there's a reason I was thinking about fruit, because I was thinking about with customs, things could be rotting in the dock if customs officials are demanding payments. But I want to sell whatever in Thailand. And I think I've got a great product. Certainly if I want to build a factory, I'm going to need all sorts of permissions and licenses and permits. Even if I'm just exporting my goods into the Thai market, I have to worry about customs, I do have to worry about other regulations, all sorts of things I'm going to worry about. If I'm doing business with the foreign government, if I do government contracting, if I'm a pharmaceutical company and I want to sell my products to state-owned hospitals or to the health ministry, then all of these things, if I know that this is a country with a big corruption problem, even before I get into the specifics, I can anticipate, if I'm trying to estimate the costs of entering into various markets, the costs are going to be higher. Now, on the buying side, it's not as obvious, as I said, because you don't think you're interacting with government officials as much, but maybe, right? Maybe if you need government permits to export certain things. So for certain kinds of goods, you need permission not only to export into that market, but to export out of that market. So I might think like, I don't know if I want to get into this business here because some government official is going to say, sorry, you've exceeded your quota of whatever it is you're exporting from. You want to move out of this country, so you need to pay bribes. That could be going on. You could worry for other reasons that maybe your suppliers are going to get shut down or going to get into trouble. So it's not as obvious. I can't think of any direct way that the Foreign Corrupt Practices Act would create a legal risk if you're purchasing goods from a company or from a country where there are concerns about corruption. Now, I could be wrong about that. I'm not giving legal advice to anyone who's watching, but that's not as obvious. Now, turning to the second part of your question, the fact that many companies are using these indexes. So for those of your listeners who don't know, or the viewers who don't know, the Corruption Perceptions Index is produced by an organization, a non-governmental organization called Transparency International. It's one of the major international NGOs devoted to anti-corruption. It has a headquarters in Berlin. They also have a research department as part of that headquarters office, and then they have a number of chapters in individual countries, though not currently one in Thailand. These individual chapters work on a variety of different issues. They act as anti-corruption civil society activist groups in those countries. But the central office, every year, and they've done this since I think the late 90s, releases this index that gives a score and a ranking to every country in the world with respect to how corrupt or clean it is. Transparency International actually doesn't do the rankings, or they don't do the scorings themselves exactly. There are a bunch of other organizations out there that produce these scores. They're often investor services firms, for example, that are trying to evaluate market risk. There are also organizations like the World Bank, for example, or some others that do these assessments. And then what Transparency International essentially does is it averages the numbers. It's a little bit fancier than that. They've got some statistical techniques they use here and there, but basically they take a bunch of numbers, they find a way to put them on the common scale, they average them, and they put this out, and then there's always a press release and a color-coded map and so forth, but that's basically what it is. The P in CPI is really important. It's the Corruption Perceptions Index. Transparency International is very explicit, at least their research department is. The press releases aren't always as good about this, but the research department and the report itself is usually very good at emphasizing this is based on perceptions of corruption. Perceptions don't always match with reality. But I think to a first approximation, the CPI does a pretty good job of what it purports to do, in the sense that if your score is worse, it means generally people tend to think that corruption is a bigger problem in your country. Now, there is this issue of these things becoming self-reinforcing, because sometimes people have a perception that corruption is bad because they see the CPI score. So there's a little bit of a circularity problem. But because of this, so if you're running a company that is a multinational company and you want to be involved in many, many different countries, many, many different markets, you might look for cost-effective ways to assess corruption risk in those markets. Other kinds of risk too, political instability, for example, all sorts of risks, right? The possibility for civil violence, all sorts of risks you might want to assess. So again, there are a lot of companies out there that do analysis, like the Political Research Service Group, the Economist Intelligence Group, like they actually have people on staff whose job it is to come up with these risk assessments. Now, what Transparency International does is they take the public version of this and take the score and they just average it. So I guess some companies might have decided that instead of paying for these assessments, we're just going to take the average, take the CPI score, and use that as an input. So I don't think that's great. I think it's kind of understandable, because companies are looking to shave their costs, and this is a pretty easy, straightforward way to do it. They might be worried about making discretionary decisions on these kinds of things. But I do think the CPI is a very crude measure. It certainly is not good at measuring change over time, if that's something that we care about. And making it into a kind of automatic on-off switch. Again, from my perspective, I'm not a business person. I don't understand everything that goes into it. That seems a little bit too crude and simplistic for my tastes. On the other hand, and I'm not saying this is true of Thailand or the people that you've encountered, I don't know, but I've been in the room where these discussions are happening, and people from the affected countries, from the affected markets, get really mad at the index and the folks using the index. And some of their objections are well-founded, but it is in fact the case that whatever the problems are with the CPI, that in most of the countries that score quite poorly on the CPI, there is a genuine corruption problem. It's not like Transparency International or the other places are making it up. So I can see being very frustrated that if Thailand, I'm making up numbers, gets a 4.1 instead of a 4.3 or whatever, or I guess the CPI is not a 100-point scale, so I don't know, like a 34 as opposed to 38, and that makes a difference between like a huge investment and no investment at all. I can totally see being very frustrated about that. In the same way that my students can be understandably frustrated if they get, B plus rather than A minus, because the mandatory curve means like very small differences, like things shouldn't turn so much on that. But is there genuinely a corruption problem in Thailand? I'm not an expert. I think so. Work that you and your colleagues have done suggests there really is a genuine problem. So, there's this English expression, don't shoot the messenger. And I think to some extent, when people get really mad about companies using the CPI score in ways that influence their willingness to engage with the Thai market, although there are genuine and legitimate criticisms, both of the index and the way companies are using the index, there's also a little bit of a shooting the messenger aspect of this, that there's a genuine problem that needs to be addressed. And I would think a healthier way to respond to this problem would be to ask serious questions about why Thailand is getting a 34 and what the problems are and how those problems can be addressed.
Totally agree with that. Now we do have enough time for maybe one or two questions, but this big question need to be asked. But there are two big questions. Maybe I pack them into one. One is that I think late 2023, there was this enactment of the new law called FEPA, or Foreign Extortion Prevention Act.
Yes.
Right. Everyone was talking about this because it means that government officials outside in other countries could be convicted. But very soon later, just a year later, President Donald Trump became president, and then he put a pause on both FCPA and FEPA. So what does it mean? Am I correct? Or
did he specifically put a pause on FEPA? I don't remember
I think he put a pause on FCPA.
I've definitely put a pause on FCPA. So there was nothing under the FEPA to pause at that point. No enforcement had happened yet.
Okay, so yeah, so what's going on right now?
Okay, so let me address the second part of your question first, because we've been talking about the FCPA and President Trump's actions are most relevant with respect to that. And then I'll say a little bit about this new statute, the FEPA, the FEPA.
Thank you.
So starting with President Trump. So President Trump has been well known from his first term and before, is a critic of the FCPA, shall we say. He's described as a horrible law. This is before he was elected president the first time. A horrible law. It disadvantages U.S. businesses. He complained about it during his first administration to his Secretary of State and others. He's very much of the view that when American businesses go abroad, they should do whatever they need to do to win business and get advantage, and that the United States government shouldn't be limiting what American firms do abroad. It's their business, not our business. When we're going to lose competition, we're going to lose competition for business and other things, right? So, in his first term, he said this a lot, but nothing really happened. His Attorney General and the Deputy Attorney General, who ran the criminal division in the Department of Justice, and the Securities and Exchange Commission, they remain generally committed to FCPA enforcement, so we didn't see that much of a change. The second Trump administration is quite different. So he, within the first month in office, issued an executive order declaring a 6-month pause on FCPA enforcement while there would be a general review of what to do further. He essentially disbanded the specialized unit in the Department of Justice that focused on the FCPA and reassigned those attorneys to things like drug crime enforcement and immigration enforcement. And the executive order that he gave, or the statement that he issued with the pause, included a lot of language in it suggesting a general skepticism of the FCPA and endorsement of the view that U.S. foreign policy interests should shape the direction of FCPA enforcement or non-enforcement. As an aside, we haven't talked at all in this conversation about the OECD's anti-bribery convention, but largely thanks to American diplomacy in the mid-1990s, there is a convention housed at the OECD, but not limited to OECD members, in which all members pledge to adopt and enforce their own laws like the FCPA, prohibiting foreign bribery. An article of that convention specifically prohibits countries from using reasons of national interest, economic or foreign policy interest, as a reason, as something that would influence their FCPA, or their foreign bribery, I should say, enforcement decisions. So it seems quite clear from the President Trump's order that he's not in compliance, but I don't think he cares. And anyway, but turning back to the order itself, so there's a 6-month pause. There's essentially the dissolution of the specialized unit, and it's not clear what will happen after the 6 months, but I think it's highly likely that there will be a general declaration this is not an enforcement priority for the United States government. So what are the implications of this? Well, I do think, my prediction, which could well be wrong, my prediction is that although we did not see such a substantial decline in FCPA enforcement in President Trump's first term, we will see that in the second term. I would be surprised if that weren't true. Even cases that are ongoing, I think we're supposed to be subjected to review. And so I think that's a big thing. I think there's a longer-term consequence too, which is the dismantling of the enforcement apparatus means that we're going to lose a lot of expertise, a lot of human capital, essentially, that knew a lot about the statute, that had a lot of experience enforcing it. I think that's going to decline, such that even if either the President Trump himself or more likely a successor administration decides to change course on the FCPA, it's often easier in government and elsewhere to destroy things than to build things. So I think it will take some time to just get the institutional capacity back to where it was before. Now, I will say, for those people who wonder, like, well, is the FCPA just dead? Can companies just start ignoring it now? I think that would be an awfully risky thing to do. It would be risky in part because just from a straightforward enforcement perspective, the FCPA has a 5-year statute of limitations. The statute of limitations runs from, if it's an ongoing conduct, it runs, if I remember the law correctly on this, runs from the latest act that's part of the ongoing conspiracy. So if you can show that like 20 different violations of the FCPA, 20 different bribes were all part of the same bribery scheme, then the statute of limitations starts from the latest in time. If they're completely separate, then the statute of limitations for the first one might run out before the second one does. But anyway, so this means 5 years from now, there will be a new administration. Now, it's possible President Trump or someone who wants to follow his policies will still be in office, but it's possible not. Right? It's possible that a new administration will pivot again and will start taking a really hard look at what companies were doing during this FCPA pause. So if I were the general counsel of a company or a lawyer, an outside lawyer advising a company, and they were saying, can we just relax our FCPA anti-bribery compliance programs now, or can we just create a new slush fund to start paying bribes to win business? Lawyers usually are pretty cautious by nature, but I would say no, don't do that. And I think this is, if you see the client alerts that law firms were sending out, at least the public ones, after this announcement, a lot of them were saying, just remember, there's a statute of limitations, the conduct is still unlawful just because the administration has currently decided they're not going to enforce it. It's not like an immunity. They didn't say anyone who violates the FCPA now will be immunized from prosecution. They're just not starting any new cases, and they're reviewing the old cases. So I would say they'll be very cautious. Now, if companies said, yeah, but that's not the question. The question is, we've got a transaction that we really want to do. We don't think it violates the FCPA, but there's a risk. Like, can you evaluate how much risk we're running? I think I would objectively say the risk is lower now than it would have been a year ago. I might say, well, look, of course you obviously shouldn't deliberately violate the FCPA. If you think this is probably not an FCPA violation, if you think your partner, you've done some diligence, you think partner's probably clean, you might have been worried a year or two ago that if you ended up being wrong about that, that the Department of Justice, the SEC would take a hard look at you and would launch an extensive investigation, even if you ended up being, if not exonerated, if they decided not to go after you. It would still be very expensive just to do all the investigation, all that. Now, as a lawyer to the company, I might say, I don't think you need to worry as much about that. It's not a zero risk. Again, policies could change, but the risk is lower. So I do think, I don't want to say it makes no difference at all. It probably does. But it's also not like this order legalizes foreign bribery. There would still be a pretty substantial risk there that you would need to take into account, for sure.
But as you mentioned, if you were the general counsel of the company, you would advise not to disregard the FCPA.
Absolutely, but again, I think oftentimes these are calculations based on, again, you would never, if you're an ethical general counsel, you would never advise breaking the violating the statute, but there's uncertain situations. There are gray area cases, and things like the Trump administration's order affect relative risk calculations. And so, I think it will make a difference. I think the difference will probably be bad, generally. But I do think that people in the private sector, let's put it this way, some of the people that you mentioned you've talked to before in Thailand, maybe some of the people in the audience for this podcast, if they might have been expecting that after the Trump order, the American businesses would stop exhibiting concern about the FCPA, would stop taking those issues into account, I think they're going to learn that that's not true. And another thing to keep in mind here, I mentioned the OECD convention before. Historically, the U.S. has been by far, the most aggressive and the most important enforcement of laws against transnational bribery. But the U.S. is no longer the only enforcer of such laws, and other countries are starting to enforce their laws more aggressively. And like the United States law, some of these countries have sufficiently expansive jurisdictional provisions that they could affect companies even that aren't necessarily domestic firms of those countries. And multinational firms will often want to avoid bribery generally because they don't want to get in trouble with anyone, so will often involve a more cautious and conservative approach. So you need to be worried about the United Kingdom, you may need to worry about Germany, you may need to be worried about Canada. There are a lot of other issues. So I do think the pause in FCPA enforcement is quite significant. I think it's the first major reversal in the expansion of FCPA enforcement we've seen, I think, since it really picked up, again, starting in the late 90s and early 2000s. It remains to be seen what will happen after the 6-month pause. So it's quite a significant development, very worrisome development. It doesn't mean that the FCPA has been repealed or that foreign bribery has been legalized in the United States. Now, you asked about the so-called Foreign Extortion Prevention Act.
Yes.
The context here is that the Foreign Corrupt Practices Act focuses on what's sometimes called the supply side of foreign bribery transactions, the bribe payers. It doesn't focus on the so-called demand side, those who receive the bribe. So again, if I am an American firm and I want to open my factory in Thailand and you're the local official from whom a permit is necessary to open the factory, and I offer or pay you a bribe, then the FCPA covers my conduct, doesn't cover your conduct. Now, one would hope and expect that there is Thai law that covers your conduct. Every country in the world that I'm aware of has laws, at least on the books, even if they're not rigorously enforced, that prohibit their government officials from taking bribes.
Of course.
Right? Or changing their decisions in order to receive these kinds of private benefits. But U.S. law, traditionally, would not criminalize your conduct in soliciting the bribe. So imagine I don't even pay the bribe. Suppose you ask me to pay you a bribe, and I don't pay it. Again, Thai law would probably criminalize your conduct. I assume that Thai law would criminalize a public official requesting a bribe, even if that bribe wasn't received.
Yes.
But American law wouldn't criminalize the conduct of the Thai official. Now, I will say that even before FIFA was enacted, there were ways for the United States government, if it chose, to go after public officials who took bribes in certain circumstances. Most notably, the anti-money laundering statutes. So there are some cases where the people who took the bribes would funnel the money through or park the money in the United States. So there's a famous case involving Thailand with a Thai film festival where an entity, I think it was a U.S. entity, or filmmakers had bribed some Thai government officials with respect to this film festival, and it was the official and her daughter who weren't prosecuted directly under the FCPA, but were prosecuted in the United States under the anti-money laundering statutes because I don't remember the details, but some of the money went through or to the United States. And bribery would be one of the predicate offenses that can serve as the basis for, basically to contain the money and then use that as the basis for a money laundering prosecution. But That's only limited to certain circumstances. What the Foreign Extortion Prevention Act did is it said it's a United States crime, a crime in the United States for a foreign public official to request, demand, solicit, receive a bribe from an American firm or entity. Now, so again, that addressed this concern that the FCPA only went after the so-called supply side of bribery, not the demand side of bribery. A lot of times American firms would complain, like, you make it seem like we're the bad guys. When we go to do business in this market and we're getting regularly solicited for bribes, we're told, you're not allowed to do this or that. The FCPA doesn't really have a defense of economic extortion. So you can defend against an FCPA prosecution if you can show you were threatened with physical violence. So if, for example, a government official says we're gonna kidnap your employees unless you pay me a bribe, or the example that sometimes given is we'll blow up your oil rig unless you pay us off. So there, if you make the payment, you can say the payment wasn't done corruptly because it was under duress, it was being extorted. But economic extortion doesn't count. So companies would complain, like, what are we supposed to do? We're being hit up for a bribe. We can get in criminal trouble if we pay the bribe. But the actual bad guy is the foreign public official, right? So FCPA is meant to address this and give the U.S. the power to go after the so-called demand side of bribery. It's controversial because the United States government is asserting the authority to prosecute not just a foreign national, but a foreign government official for conduct that took place abroad. Right? It's not limited to the foreign official was in the United States and asked for the bribe. So obviously there are concerns about overreaching and extraterritoriality and so forth. There are also questions about how it would be enforced. Would a country be willing to extradite its nationals to the United States? Maybe FCPA would end up being a kind of de facto travel ban, for example, because if the United States issued an arrest warrant for, let's say, you're a Thai government official, and Thailand wouldn't extradite you, but still, if you travel to the United States or a country with which the U.S. has an extradition treaty, as soon as you set foot there, it's possible you could be arrested. So it's right, as you said, in late 2023 and early 2024, a lot of people in the anti-corruption community were very interested in this. Some were very excited. Other people were concerned or skeptical. People were writing a lot of articles about what exactly is this going to mean, what's the impact going to be. It has, to my knowledge, I could be out of date on this, to my knowledge, has not yet been enforced. I don't believe the Trump administration's official pause on FCPA enforcement mentioned or extended to FCPA, which is a separate statute, but I am skeptical that we'll see the administration attempt to enforce this statute. Now, I'm not 100% sure of this because in some ways enforcing the FCPA statute doesn't raise many of the same concerns that President Trump and his associates have about the FCPA. Because it's not seeking to penalize U.S. firms. In some ways it could portray it as trying to help U.S. firms by going after the bad, corrupt foreigners who are extorting money from the U.S. firms. So I could imagine if there were an advisor to President Trump who really liked FCPA, you could make the case that actually, even if you want to pause FCPA enforcement, you should really ramp up enforcement of FCPA to help U.S. firms and to get those corrupt, bad foreigners. The reason I'm skeptical that will happen is I think it's just not the administration's priority. I think foreign corruption is just not a priority of the current administration. As I said, they're reassigning attorneys who have traditionally worked on these issues to things like immigration enforcement and drug enforcement, things that are higher priority for the administration. These would be hard, complicated cases. They're not doing anything, to my knowledge, to build the capacity that would be necessary to bring these kinds of actions. I think my suspicion is that President Trump and those around him don't want to call a lot of attention to the issue of foreign corruption because there are so many concerns about corruption in the Trump administration and the Trump business organization itself. I don't think this is an issue that he or his family or associates want to be in the headlines. And also just ramping up enforcement of a brand new statute, getting a team together, finding the appropriate cases. Again, these would be hard cases. They would involve principally overseas conduct. And often you would be trying to collect evidence in a foreign country that is not happy that you're doing this. So they'd be really challenging cases. And my impression is that the Trump administration's Department of Justice does not currently have the competence or organizational capacity to take on the challenge of rigorous enforcement of this new statute. Now, if next week we hear the report of the first FCPA action occurring under the Trump administration, I will acknowledge that I'm wrong and predictions are sometimes wrong, but I don't think we're going to see much in the way of FCPA enforcement for a while. Now, I will say, We didn't see much FCPA enforcement for a while either, so I don't want your audience to misunderstand me as saying FIPA is insignificant. It's on the books, and it's entirely possible that 5 years, 10 years, in the case of the FCPA, I would say 20 years from now, some enterprising prosecutors confronted with a difficult situation with the foreign government, set of foreign government officials repeatedly extorting firms will say, we have this statute, let's find a way to use it aggressively. So it is certainly possible that will occur, and so people need to watch that. And so all of both the enthusiasm about FIPA and the concerns about FIPA, they're not irrelevant. I am skeptical that in the short term it's going to be all that significant.
So although this is the situation today in the short term, in the long term, we still have the FCPA, FEPA, and as you mentioned, not just in the United States, in Canada, in many European countries, they do have laws similar to this as well.
Yes.
So be cautious about this, and take note that even if you think that Thai law on anti-corruption might not be as effective or efficient, but there are laws that could convict you outside Thailand as well. So, and we learned a lot about FCPA, VPA from Professor Matthew Stephenson today. So thank you very much for your time.
Thank you very much. Thank you for having me on your podcast.
Thank you.